Well, Sheila, it's good to see your face.
Good to see you as well. Thank you. Well, thank you. Good morning. My name is Sheila Timberlake. I am a paralegal with the Lone Star Legal Aid. Lone Star Legal Aid is a nonprofit law firm that provides free civil legal services to low-income applicants. In celebration of the work that many volunteer pro bonos perform for the clients that we serve, we have set aside both nationally as well as statewide celebrate pro bono to observe and to thank the volunteers for the work that they do for our clients. If you would like to make application with Lone Star Legal Aid, you can do so by calling us at 1-800-866-0821, or you can make an online application at lonestarlegal.org. Please be informed that today's webinar is not intended to serve as legal advice, but it's for informational purposes only. But if you have any specific questions, again, about a legal issue, you can call us at 1-800-866-0821, or you can make an online application at lonestarlegal.org. I am pleased to be joined today with our speakers, Mr. Steve Crane with East Texas Disability Advocates, and Shirley Parnell, who is a claims representative for the Social Security Administration. Good morning, Ms. Parnell and Mr. Crane.
Good morning.
Good morning.
Mr. Crane will introduce himself and he will begin our presentation, after which Ms. Parnell will come in and she will do her presentation after she introduces herself. Thank you, Mr. Crane.
Thank you, Sheila. So again, my name is Steve Crane. I'm a non-attorney representative. I was a paralegal with Lone Star Legal Aid. At the time, it was East Texas Disability Advocates for many years. And in that position, I handled a number of different types of cases with regard to supplemental security income or disability insurance benefits, everything from doing applications and representing people in disability claims to overpayments and a variety of other issues related to public benefits. My presentation today is going to cover kind of the appeals process a little bit, and we're kind of getting ahead of ourselves here. And Ms. Parnell is going to be talking about from Social Security perspective, and what their rules and regulations say. And I'm going to be offering information on insights from a representative's point of view and actions that the client can take to make sure that problems with overpayments are prevented, but also once they get notice of overpayment, what they can do. So my topic is really going to cover filing a reconsideration, as well as some pointers and some information that is available to claimants online to help them if they have problems with overpayments. So what people need to understand is when they receive a notice of overpayment, that overpayment is going to explain in fairly good detail not necessarily how the overpayment came about. It will give some general information about that, but more accurately, or not more accurately, but in more detail, determine how that overpayment, how much the overpayment is, and how they arrived at that amount. And I think it's important for claimants and anybody representing a claimant in an overpayment to understand is that a reconsideration is oftentimes the only way that you can determine what the exact nature of the action or actions that took place to create the overpayment. That's not always adequately explained in the notice of overpayment. There are three different types of reconsideration that a person can request, and the form itself lists either a case review, an informal reconsideration, or a formal reconsideration. A case review is simply a review of the determination that was already made, and that review is performed by the person that made the determination of the overpayment. An informal review is a review by somebody, another case analyst in the Social Security office, a claims representative in the Social Security office, and it provides an opportunity for an in-person, or at this point in time, a hearing of some sort, whether it be by phone or video, to review the overpayment, how it was created, and the amounts. And a formal review gives the claimant and the representative the opportunity to call witnesses, and that's in addition to the informal review, where you get an explanation of how the overpayment came about and how they arrived at the amounts. I think what's important for people to understand is that getting an explanation of that overpayment is extremely important, because it's an opportunity for the representative or the client in particular to determine the exact nature of how that happened, because there may be some information that was missing in the determination that Social Security did not have, and that can oftentimes be corrected. As a representative who has performed this kind of work for a number of years, not necessarily in overpayments necessarily in the recent past, but you know, the informal conference is a valuable tool to determine the nature of the overpayment and the exact amounts. It's not uncommon for the Social Security Administration when you have this different set of eyes looking at the facts surrounding the overpayment, they may oftentimes find that there was something that the prior claims representative didn't see. And I will say I want to say this from the get-go, that we have on my office, which is East Texas Disability Advocates, has a very good relationship with the claims representatives at the Longview Social Security office, and we have a good relationship because we're open and honest with each other, and we're knowledgeable about how the rules work, and having that relationship is extremely important for a number of different reasons. And I say that because the claims representatives, there's a lot of, at this point in time, there are a lot of people who've been there for a long period of time, very familiar with the rules, but there's the attrition going. A lot of people are retiring, and there are a lot of new people coming aboard. And the new folks are not necessarily as well informed as some of the folks that have been there a long time. That doesn't mean that they're incompetent. That's not what I'm saying at all. I'm just saying, as from a representative's point of view, that the level of experience that a claims representative has, it can be the determinative factor in how the initial or the outcome of the overpayment. So, having said that, the informal review, that's kind of what I'm going to focus on, because I think that's the most effective tool that a representative has, and the one that I've used the most often. But again, that will depend on the facts of the case and whether witnesses are necessary. But at that point is when you can also ask for the production of documents or information and sources of information that were used in determining whether there was an overpayment that occurred. Now, I think it's really important for people to understand that this appeal process is the same for either a Title II disability claim, which is the disability insurance, retirement, survivors, or disability insurance benefits program, and Title 16 or supplemental security income. But overpayments for the two are completely different. I mean, you have an entitlement, which is the disability insurance benefit, and then you have the needs-based test for supplemental security income, and the opportunities for overpayments in the SSI cases are much greater. And in part because their reporting requirements are much more detailed than they are for Title II or disability or retirement or survivor's benefits. So I'm going to share my screen right now and see if you can see. So can you all see my screen?
Yes.
Okay. So what I'm looking here at right now, this is a Social Security handbook. All right. And this is important. It's what's important to understand that this is more for the general public. So for claimants that might have access to the internet, this tool is very helpful for answering questions in a number of different areas. The most areas that I get are about employment, and I'm not going to go into that, although that is oftentimes a basis for an overpayment. So I came down here to 19, and that's where we're at on the this is section 19, the table of contents for underpayments and overpayments. So this information is very helpful in understanding how to deal with overpayments. I'm just going to cover, well, I'm just going to cover right now. I would like to have Ms. Parnell here very quickly for a very short manner time to go ahead and deal with overpayments. I am going to say that from a representative standpoint, there are two things that are really important when a representative is helping an individual, whether it's in a disability insurance benefit or SSI client. I'm always looking at how what I tell that individual might impact their benefits in the future. And so I always emphasize the importance of reporting any changes, especially changes of address, because how that is so important. If a person is undergoing a continuing disability review, for example, if they don't respond within an appropriate, if the claimant doesn't respond within the appropriate time, benefits can be stopped. So reporting simple things like a change of address is really important, but any changes of income are also real important. And Ms. Parnell is going to talk about that and a little bit about what you should be doing as a client or as a recipient of disability or any kind of benefits from the Social Security Administration, if and when you report information and you don't receive something from Social Security. So I'll probably have some additional comments to talk about after Ms. Parnell gets through with her discussion. And I don't know what's appropriate for questions, Sheila, but if you have any questions, or are there any questions in the comments that people might have?
We are monitoring the chat as well as the Zoom, and so far there are no questions. Okay.
I would like to know, I'm sure that the legal aid staff are already very familiar with the POMS and the Code of Federal Regulations with regard to Social Security in general, but specifically with overpayments as well. But I'd be happy to provide that if people feel like they need it.
Thank you, Mr. Crane.
So Sheila, do you want Ms. Parnell to take over at this point?
Yes, we are waiting for Ms. Parnell too.
Okay.
Yes.
Good morning. This is Miss Parnell. I work at the Longview, Texas Social Security Administration. My job title is Claims Specialist, and my specialty is the Supplemental Security Income field of the Social Security, and some people refer to it as SSI. Some of the most common overpayments we see usually are a wide range of things, resulting usually from some kind of income or money that's received in a household that wasn't reported to the Social Security Administration. That could range from like pay stubs not being turned in on a monthly basis, child support not being turned in on a monthly basis. It could even be something as not regular, but like a lottery winnings or any kind of income. It could be someone giving you a gift. Say if you ask for money to help pay your bills for the month, that could count as income also. The main way to prevent the overpayments is to make sure you report any income received in a timely manner. One of the ways that you can report your pay stubs monthly is on an app on a smartphone called a SSI Mobile Wage Reporting app. And what you do is you add up your gross wages for that month and report them the first week of the month after. So like, for example, for the month of October, you would add up all your gross wages for any pay checks that you received during the month of October and report those on the first week of November. And that will automatically update the Social Security system. Another way, if the computer just doesn't work or if you don't have access to a computer, you can call in the wages at 866-772-0953. You can also fax them to our office. The fax is 833-939-2025. And you can also mail them to our office at 611 Clinic Drive, Longview, Texas, 75605. Now, just say, for example, you do get an overpayment and you agree with the overpayment, but you can't afford to pay it back. That's the time when you ask for a waiver, and that's submitted on a SSA Form 632. And you might be able to afford a small payment, so you can ask on that waiver form, you can ask for a smaller payment plan at that time. Say you can only afford $20 a month or $10. You can write that on the waiver form and we can work with you on reducing the payments that's collected every month. Now, if you don't agree with the facts of the case, that's when you submit an appeal form, and that's done on a SSA Form 561. And for child support, it counts as unearned income on a case, and it's counted with a 1/3 reduction. So, for example, if your child support is $300 and the parent that's paying the child support is not living in that household, then the 200 of that 300 would count as unearned income on the case. If the parent that pays the child support also lives in the house with the child, then it would only be like a $20 general exclusion, and the rest of it would count as unearned income. If there's any back child support that's owed called arrearages, those would usually count as income to the parent and not the child. Is there any other questions about any of those
We have
items?
a question.
Yes, ma'am.
Yes, Ms. Parnell, and I believe you've covered it. We do have a question in the Facebook Live that says, how can we get proof of overpayment if our client says they never received notice?
we could probably look in the file and find the notice. If there was no notice given, then we might have to do some other actions.
Sheila, I would like to interject that too, is that if the client had changed address and had not reported that change of address, that would be a good cause for not receiving the notice timely anyway for purposes of appeal. But and I forgot to add that having a good relationship with the local office is extremely important, and because it's invaluable. Oftentimes, overpayments can be resolved with just a phone call and to the claims representative who handled the client. But if I understood Ms. Parnell correctly, the claims representative, whoever answers the phone, whether they were the ones that handled the case or not, can look in the system and determine whether a notice was generated, and if so, to which address, and the date of that notice.
Thank you, Mr. Crane. Thank you, Ms. Parnell. There is another question that's in the chat, but it relates to child support overpayments, and I will wait until that has taken place. But as far as the overpayments, I believe that's the only question we have.
Okay, well, what is specifically the question about the overpayments for child support?
Just how do you get proof of the overpayment if an individual says they never received notice of the overpayment?
Okay, well, and that's where the informal conference comes in. You have to file.
Yes.
You can the phone call to the Social Security office. You know, they'll send you. And Ms. Parnell will correct me if I'm wrong. If you're a representative, obviously you have to have the 1696 in place before you can even talk to the Social Security Administration. But if you have, for example, if you're doing an interview on the phone and you don't have that 1696 in place, very common for me, because I do a lot of work with homeless shelters, I'll just conference in the Social Security Administration, who will then speak to the claimant to make sure that person is who they say they are, ask for permission to talk to me, and if the claimant says yes, then I ask the question. So under, and that's kind of an office by office determination. Not everybody, not all Social Security offices will do that. Because the nature of the confidentiality of the information that's being shared. But the informal conference would be the best way, because at that point you can ask the Social Security Administration to provide documentation as to how that overpayment came about. So I don't know if that answers the individual's question or not, but I'd like to know if it doesn't.
Thank you.
So, Ms. Parnell, let's talk a little bit about the waiver, and because there are two requirements for a waiver. One is that you have to show that you're without fault in creating the waiver, and then the second requirement is either repayment would defeat the purposes of the act, or it would be against equity and good conscience. Do I have that right?
Well, what we usually look at is if the person is not at fault, and do they have the ability to repay?
Right, and so let's talk a little bit about without fault. From when you're looking at an overpayment, what does Social Security consider to be without fault? What are they looking for, or what are you looking for?
Let's say someone faxed in their pay stubs, and for some reason we never input them. then that could mean that they are without fault because they did submit their pay stubs in a timely manner, but we just failed to input them. That could be without fault.
Okay. So let's say a person reported it and the Social Security received it, and that person continued to receive benefits. How would that impact without fault?
But we'll look at it and see, everything is on a case-by-case basis. But we try to give the beneficiary the benefit of the doubt if they did what they were supposed to do, and it was on us that we didn't do what we were supposed to do, then we probably would waive it.
Right. So, and I think this kind of brings up a point that I referred to earlier. What should a claimant expect when they report information to the Social Security Administration? What should they expect from Social Security, and give us kind of a time frame as to when they should expect that?
Usually, if you make any changes with us, you should get a letter probably no later than 10 days after that to show what changes were made. It could be like an address update. It could be a bank account update. It could be reporting wages. Because the wages just say the wages for the month of October, those affect the check 2 months later. So as long as we get the wages in there for October by November, then the check in December will be affected. And so you should be getting a letter that says how your check's going to be affected by those new wage input.
Because I have found that in the past that, I think it's really important for claimants to understand that when let's say they start working, well, they're reporting their Social Security number to the employer. The employer, if it's, taxable wages, are reporting that information to Social Security. Claimants need to understand that just because you've done that and Social Security, you're paying your Social Security taxes, and Social Security will receive those, taxes and credit them to their account, doesn't mean that they've reported their earnings to Social Security. There's a lag time, first of all, and then before those earnings are actually posted to the person's Social Security account. And then, I don't know quite how it works on your end, Ms. Parnell, but it may be a couple of years before somebody catches it at the Social Security office. And so to give you a very specific example, when I was working for Lone Star Legal Aid, we had a person call for services, and they said that they had called the Social Security office and reported those earnings, and they continued to receive benefits. And they thought, well, I guess everything's okay because I reported it. They're still sending me benefits, so it must not be counted. And the claimant's responsibility doesn't just stop with reporting that information. If they've reported that information and continue to receive benefits, and they think maybe they shouldn't be receiving benefits, or they should have been a reduction in benefits, I think they still have an obligation to follow up and make sure that that information is correct. Because once I got the case, the overpayment was, I think, like $30,000. And when I asked the claimant, I said, well, when did you report it? Well, I don't know. That was a long time ago. Well, do you remember who you spoke to? No, that was I said, well, how are we supposed to prove that you reported that information to Social Security? Because at that point, it's going to be very, very difficult to prove without fault, which is the first requirement. You must meet that requirement in a waiver before Social Security can even consider whether or not you have to pay it back, and if so, if they'll work out some sort of arrangement.
Yes, that's a hard one.
So, I think people, representatives in particular need to remember that it's not uncommon for claimants to either, to not receive the notices, either because they've moved or for whatever reason. It's not uncommon for claimants to not receive notices, and that if there's no period of time. No, there is a 60-day requirement to file an appeal, but there is no such time limitation for a waiver. Although, if you want to file a waiver in order to kind of to keep the Social Security Administration from withholding the benefits immediately, you have to do it within 30 days. Is that correct, Ms. Parnell?
What was that again, sir?
Like, for example, if let's say, well, there are two things. First of all, let's say the individual gets notice of an overpayment. They can file an appeal and file a request for waiver at the same time.
Well, we want them to, usually we want them to file one or the other. The appeal is if they don't agree with it. Like if the numbers are wrong or something like that. If they agree the numbers are all right, but they just can't afford it, that's when they do the waiver.
Right, but there's nothing to stop the claimant from filing both at the same time.
No, they can.
Right.
But usually one is more prevalent.
Right. So what's important is that if a person files an appeal or a waiver, the Social Security Administration will suspend collection until that determination is made. Is that accurate? Or until a determination is made on either the reconsideration or the waiver?
That's right. When they file a waiver, we put the collection on hold until we make the decision.
And you have to file the waiver within 30 days of the notice. Is that correct? In order to suspend collection?
Well, whenever they call us to ask for a waiver or submit the form, that's the time that we suspend the collection.
Okay, so if I've been repaying an overpayment for a period of time and I've never requested a waiver, I can still request a waiver, even if it's after the 60-day time period. I can request a waiver at any time. And will the Social Security Administration then suspend collection until that overpayment has been determined?
Yes.
Okay. So I think that's something important for representatives to understand too, that even though they may not have an opportunity to contest the overpayment because they didn't file a timely appeal, and there's no good cause for extending the time period to appeal, then that waiver could be a vehicle for suspending collection and determining without fault, and if nothing else, at least determining whether to reduce the amount of the collection of the overpayment. Which kind of brings me to another point, and we didn't really discuss this, Ms. Parnell, but there's what is that? It's called a compromise settlement agreement. Are you familiar with the compromise settlement agreements?
Not as much. Are you talking about where they want to pay a certain amount?
Right. Well, let's say, for example, that the person has, if I understand how that works, Miss Westbrook is raising her hand.
Good morning. I've just been listening in on the call. It's a lot of good information, but I did want to comment on that. We can do a compromise settlement. That is something that is not often a vehicle that's not often used. We do have to consult with our regional office depending upon the amount of the overpayment, but it is an option for settlement of an overpayment.
And for the audience, Ms. Westbrook is a supervisor at the Longview District Office, and a very experienced and a well-respected person from my viewpoint. She's been around for a long time. It's been extremely helpful in helping claimants. And I think I wanted to say this too, that really that's Social Security and representatives, while we may butt heads on certain issues, the bottom line is that we both have the claimant's best interests in mind. And we just have coming from different perspectives. So, but the compromise settlement agreement, if I understand correctly, is only available when it's very clear that the person doesn't have the financial means, whether it be income or resources or both, and that repayment of the overpayment would not take place within a reasonable or appropriate period of time. Is that accurate, Ms. Westbrook?
I'm sorry, Mr. Crane. Could you say the very last part of that again?
Yes.
You understand that I have 3 or 4 things going. I apologize.
Well, that's okay. So there are 2 requirements for the compromise settlement agreement. One is that it's not just about not being able to afford it, but there are it's also that there's the overpayment's not going to be repaid within a reasonable amount of time. I don't
That's
know
correct.
what reasonable is, and that's, I guess, the regional office determination.
Right. It's like we work with them. Some of that falls within our purview, but a lot of times when you get into compromise settlements, you get into thousands of dollars worth of an overpayment. So when we think about stewardship, this is just not, a fund that we're paying. And we know it's a needs-based fund, but this is taxpayer fund. This is mine and yours.
Right.
Our money. So we look at it from a stewardship standpoint as well. So all of that is considered in the amount. And sometimes the ones that I've been involved in, like a certain portion may be waived, whereas the individual may be held responsible for the remainder of it. So.
Okay.
Mr. Crane?
Yes.
Can I comment also on when Shirley was talking about, Ms. Parnell was talking about the waiver in the appeal, and you were stating that they have a right to file both, and they do. And I always, encourage my employees to make sure that they offer what our claimants can, all of their rights, let them know what is available. But to also explain the purpose of a waiver and the purpose of an appeal, because what happens a lot of times is we get caught up in a lot of paper, whereas like the appeal may not even be viable. It's like you worked, you made the money, it's a viable overpayment. It's correct. It's a correct overpayment. Sometimes we'll go back through the wages and they'll say, yes, I earned all of that money. So we have now a formal appeal that we're having to address when we know, that information was correct. So in a lot of cases with the SSI program, it's that the information is right. It's just that they have inability to repay. So a lot of times when I'm counseling someone about an overpayment, I always, especially with needs-based individuals, I would tell them, a waiver would be what I would tell my mother to submit, because we know that the overpayment is correct. We know you owe the money, but you may not be at fault, or you may not have ability to repay. And one thing about that is with SSI, we automatically consider that they have inability to repay. So what becomes primary is whether you're at with or without fault. So like Ms. Parnell mentioned earlier, if we find that you reported those wages, or like you pointed out, if you talk to an individual, you have a name, I talked to so-and-so on such and such date, I reported that income, you know, if you, those kind of things lead us, like to Ms. Parnell stated, to side with the claimant in the fact that they've provided this information, they reached out to attempt to provide this information to us, and we failed to, you know, pick up the ball and roll with it. So we're more willing to side with them rather than to hold them responsible for the overpayment. So I always encourage people to file waivers if that's applicable. Now, if the appeal is applicable, you know, if what we have is wrong, definitely do that. But more often, it's the waiver that applies, the waiver request.
Right. And that's an excellent point. That's really kind of up to the representative. And I think it's to make that determination as to which is the best option for the client. And unfortunately, and I think that the primary goal for the representative, from a representative's point of view, is that, you know, to make sure of the reason for the overpayment, to decide whether or not to appeal it. Sometimes the only thing that you can do from a representative standpoint is file the appeal and get an informal conference for a full explanation of the facts that created the overpayment. Now, if you file the appeal within 30 days, and you have 60 days to file the appeal, but if I understand correctly, the appeal will suspend the collection of benefits until that appeal is decided. Is that correct? Ms. Parnell or Ms. Westbrook?
Shirley, did you want to answer that? Okay. Okay,
You better get that one.
okay. Go ahead. Yes, anytime that you turn in an appeal, we're supposed to input that, and that is supposed to stop the suspension of the recoupment of the overpayment. Sometimes it will, I mean, depending upon when we input it into the system, it will start to recoup that money, but there's the system is programmed to delay the recoupment of those overpayments automatically. But every once in a while, you know, there's a systems issue. So if the person contacts us and say, well, I filed an appeal, but the money is still being taken out of my benefit amount, then we'll go in and we'll input the fact that they filed a waiver and appeal so that it suspends that. Because every once in a while, we would love to believe that, you know, we're on top of everything and we're working our mail within the same week, but I wish I could say that, but that's not true, because the overwhelming amount of paper and mail and phone calls that we receive, you know, sometimes it's just not feasible, unfortunately. So when it's pointed out to us, and with you all advocating for individuals, you know, it's no problem. And Mr. Crane knows that if there is something that has not been done, and if you try to get in contact with a caseworker and they're not available, you can always ask for a member of management, and we're able to go in and try to help with those things as well.
Yeah, I want to give kudos to the Long Beach Social Security Office, because they're really good about doing that. And when they, you know, it's been said that they like to give people the benefit of the doubt, and I found that to be absolutely true. And I think that especially during COVID, the good cause is always a much easier sell than it is with prior to COVID. But I don't know how much longer that will last. I'm curious, Ms. Parnell, is the Social Security office open to the public now, or is it still just doing phone calls?
We're not open to the public right now. We're doing most everything over the telephone.
Okay.
If someone has a need for an appointment, they should call us and see what the need is and see if we can make an exception for an in-person appointment.
Okay. I think with regard to the waiver, the without fault requirement, when Social Security looks at without fault, they first look at, what is it that they look at specific? What is it Social Security looks at when they want to determine without fault?
Usually I look at when a document was received or if there was like a record of a phone call received. Those are the things I look for just to see if I can find anything. And sometimes if a person tells me, well, I talked to this person, then sometimes I'll even consider that.
Mr. Crane or Ms. Westbrook, we have a couple of questions from our Facebook chat. And I'll just go ahead and read both of those and you can respond to that. One individual says, I had an SSA representative tell me to ask for a manager-to-manager review when we file a waiver. What is the difference? The second question comes from someone who says, my parents are being docked. The monthly check is being reduced and no one can give them a reason why. Can you respond to that or provide information as to how they can get that resolved?
Okay, so the one that is has no resolution on the deduction from the check, if they want to give me a call at the office, I'll try to look at it for them.
Can you please provide that number?
Yes, it's 888-617-0455, and my extension is 22305.
Thank you so much. And I want to say this before I present this question. I want everyone to know that this presentation is intended to serve as legal information and does not replace legal advice. You can contact Lone Star Legal Aid at 1-800-733-8394, or you can reach us at www.lonestarlegal.org for more information on legal assistance. I just think this is awesome information. And the second question was, someone was wanting to know the difference between a manager-to-manager review when we file a waiver, the difference between the manager review and a waiver.
Okay,
The manager.
Go ahead, Shirley.
Go ahead. The manager is usually when the payment center is involved, and we have made 2 other attempts to contact the payment center, and if they haven't resolved the issue, then our managers get involved with talking to their manager.
Just to add to that from a management standpoint, the criteria for a manager to manager is very specific. So if an individual is having an issue, first of all, when you file a waiver, that's not a management to management issue. Okay. So say for instance, an individual had an issue, they called in and stated, my case is suspended because of, work. We'll say that. We've made an input for work, and at that person's request, getting in contact with our payment center electronically, saying this record needs to be updated. We have to give that 15 days. And we usually tell the people that, give us a call back, we'll check on it at the end. They call back, nothing has been done. We have to follow up again. And then after that 15 days, if nothing has been done and they call back, then it can be referred to manager to manager. And what happens is our employees let us know. We reach out to the management and the payment center because they no longer provide like a phone number that even we call. Ms. Parnell can attest. We don't have phone numbers to individuals anymore in the payment center. So we contact them electronically and let them know, listen, no one is taking action on this case. We need for you to look at it. And then at that point, they'll go ahead and take act. They escalate it to their management, and they actually assign that case that day for someone to start working on and get the action completed. So for a waiver, typically that input is made, and then those are assigned, but that is outside of that manager to manager process. Unfortunately, we just be waiting on the payment center to make the decision. But I can say, once I just said that, I just thought about it. Payment center does not make decisions on waivers. It's the local office that makes a decision on a waiver. The payment center makes decisions on appeals. And that goes back to what I stated earlier, making sure that we obtain the correct form, because in a lot of instances, the appeal and the waiver are submitted at the same time. And for Title II, which is Social Security benefits, all of that information is sent up to the payment center. So the appeal is sent up to the payment center and the waiver is sent up to the payment center. We have to give the PC an opportunity to make a determination on that, and we don't know how long that will be, honestly. I mean, we usually start off saying no less than 60 days. So that means that appeal and that waiver sits there until a decision is made. They only make a decision on the appeal. So once they make a decision on the appeal, if the appeal is approved, then they'll go ahead and take care of everything. But if the appeal is denied, they deny the appeal, and then they send the waiver back to the local office for us to make a decision. So now it hits someone's desk and looks like, it pretty much starts from scratch for us, because it looks like it's day one. So sometimes that makes the process even longer. So that's why I say it's important to decide, if the facts are correct, file the appeal. But if not, you can just file the waiver. As to Mr. Crane, I agree with you in that filing the appeal, you can ask for that formal determination, but informal conference. But you can also, without filing an appeal, set up an appointment where someone can meet with you and talk about that waiver. So that you don't have to wait that long period of time. Call the office, set up an appeal. A phone conference. You can conference in with your claimant. We can talk to both the rep and the claimant at the same time and explain, okay, this is the reason for that overpayment. This is what's going on with it right now. If it's already here and you're trying to get status or whatever of it, you can always call and make an appointment for that.
Thank you, Ms. Westbrook. That's very good information there. I did want to address that.
Thank you.
Sheila, I did want to address that one question about the person's check is being reduced, but they're not really sure why. And two things. Number one, my guess is that this Facebook page is going out to people all within your service area and anybody who might be watching. So it could be somebody outside of the Longview District office's jurisdiction. Is that right?
That is correct.
So I don't want to inundate Ms. Parnell with a bunch of phone calls from individuals who may not be in the Longview service area. And so if the individual who asked the question is in Longview service area, which is essentially, Ms. Parnell, what is the Longview service area?
Yes, I can give them the 800 number to call for outside the area.
All right. So
That's right.
as a representative, I would caution people that contact the 1-800 number. For two reasons. Number one, the lag time to get somebody to talk to is long. And the second thing is that it's very difficult to get all the information. They have access to the same information that the claims representative has, as I understand it. But I have found that people oftentimes get inaccurate information from the 1-800 number. I would encourage people to contact their local Social Security office, but that's just from my point of view. Ms. Parnell and Ms. Westbrook may have something to add to that.
Yes, sir. If they can look up the
I will
local
place the number
one. Go ahead.
I will place that 1-800 number in the chat as soon as she provides it so that everyone can have that number.
The 800 number is 800-772-1213. If you want to talk to your local office, if you look online and look for the Social Security in the city next to you, that should provide the local office number.
Thank you. I have someone who's live who wants to know, what if child support is ordered, but the paying parent goes to prison and is not paying? Is that payment considered unearned income?
From my experience, once a parent goes to prison, the child support won't be paid anymore because that person's not working.
And if it's not received, it's not included or considered, right, Ms. Parnell?
Right. Right. If there's no income being received, then we're not going to put the income on the record. We just need to know to update our records that the payments have stopped.
And if at that point, an underpayment could be created, and that person could be reimbursed for the months that the child support was deducted but not received.
Yes, and that just would involve calling the claims specialist for that person's case and letting them update the record for them.
Thank you. I would like to thank Mr. Crane and Mrs. Zipporah Westbrook and Shirley Parnell for providing this valuable information to those who provide so much free legal services to those who otherwise would not have access to the legal system. And I also want to say thank you to the Social Security Administration for the wonderful working relationship that we have with you with the Longview Lone Star Legal Aid Office. And again, we want to say thank you for joining and providing this information to our clients.
Ms. Timberlake, this is Zipporah.
Yes.
I appreciate the invitation. Thank you for reaching out to us, and Mr. Crane, thank you for reaching out to us. We enjoy going out into the community and especially working with our representatives, because we're both, I consider we're both on the same side. We're here to help the public. We're here to help people when they're in need. So our job is to help you to help them. So anytime that you're having issues, if something's not been done, please reach out to us, and we're more than willing to help in any way that we can. So like I said, I appreciate the invitation. Please keep us in mind during later conversations. We appreciate it.
Thank you, Sheila.
Thank you so much. Thank you.